absolutely true. He's the only lawyer in town who was not representing Eric Greitens. He's Greg Willard. Good morning, Greg Willard.
Good morning, McGraw.
Have the Greitens people called you yet?
No, I have not heard from
Breaking
Mr.
news.
Mr. Dowd and Mr. Bennett. But...
Breaking news. The only lawyer not being called in to help.
Oh, goodness.
It is the true dream team, but you are here to sort of read the tea leaves for us. Before we get started, let me just say that if I ever get elected president and I have a non-disclosure form with a porn star or a Playboy playmate, or I get elected governor and I start using the Confide app, or I start having an affair with my hairstylist, or any variations thereof, you will be representing me.
We'll have a conversation then, my friend. I don't know that any 50 lawyers is up to that task.
All right, let's get to it. So Friday, Kim Gardner, the circuit attorney, sets up a motion saying that Dowd Bennett has a conflict of interest and should not and cannot represent Eric Greitens in this charge of invasion of privacy for the city.
Right.
What is she talking about?
Let's see if we can set the stage, McGraw. Several weeks ago, the governor was sued in a civil matter in his capacity as governor with the Missouri equivalent of a Freedom of Information Act.
Right.
And the allegations were that the governor and his staff were using the Confide app, which, when a message is sent over the Confide app, it automatically self-destructs, sort of like back in the
Mission Impossible
days. And so the allegation in the civil complaint against the governor and his staff was that automatic disintegration under the Confide app violates the Missouri state statute dealing with official records of, in this case, the governor's office. The attorney general reached out and hired the Dowd Bennett law firm to represent the governor in that lawsuit. Now, let's just pause right there.
Right.
In the meantime...
Hold on a second.
Okay.
Why would the attorney general hire Dowd Bennett for that case? Wouldn't the governor hire Dowd Bennett in that case?
Well, because he was sued in his official capacity, it would start with the attorney general's office.
Right.
And I think Mr. Hawley made the judgment, correctly I think, that given the various defendants and the fact that Hawley and his office were investigating the governor's office on the same topic,
right,
that it would be difficult at best for the Attorney General's office to represent the governor. So I think quite appropriately he said, well, let's get a private firm to represent the governor in this civil litigation.
Okay.
Because we're investigating the governor on the same topic.
Okay. Just a point of order. The Attorney General of the state of Missouri isn't the governor's attorney. He's the people's attorney. Right.
He is a statutory officer elected in a general election, and he is the Attorney General of the state of Missouri. He is not the governor's personal attorney.
Okay, so he was defending the governor on a civil matter with the Confide app. How does that conflict with this?
The Dowd Bennett firm was representing the governor in that. In the meantime, then, a grand jury down in the city handed up an indictment for felony invasion of privacy charges against the governor.
Right.
He, the governor, then, in his personal capacity, hires the Dowd Bennett firm to represent him in the criminal matter.
Okay.
Shortly after that, the Dowd Bennett firm withdrew from the representation in the civil matter where they were representing him in his official capacity.
Right.
And so we've gone along now for, goodness knows, a couple of months in that sort of lineup card, if you will, McGraw. And last Friday, the circuit attorney in the criminal matter filed a motion to disqualify Jim Bennett and the law firm of Dowd Bennett.
Okay.
And the allegation is that there is a conflict of interest because the civil lawsuit where they represented the governor in his official capacity, and we'll talk about this in a moment, the circuit attorney says, well, that involved the Confide app, and so too does the criminal case involve the Confide app. And so what she is saying is that In the civil matter, even though it was the governor that was being represented, the circuit attorney says, well, it was really the state of Missouri. And the state of Missouri concurrently is prosecuting him in the city. And therefore, Dowd Bennett, says the circuit attorney, you can't represent the state in the civil matter while representing the governor in the criminal matter. Therefore, Judge Burleson, in the criminal case, we want you to disqualify Dowd Bennett and Jim Bennett in the criminal case.
Does she have a point?
Well, she makes several points, and I can editorialize in a moment. But I guess let's start with the cornerstone. She alleges in her motion to disqualify, quote, defendant's use of confide, ... to engage in criminal behavior is alleged in the indictment. McGraw, with all due respect to the circuit attorney, I've got the indictment here in the studio.
Right.
We can read this indictment, as we say in the country, until the cows come home, and you will not see one reference to confide or a similar app.
Right.
It is not alleged in the indictment.
Correct.
Period, full stop.
Okay.
So she then goes on to say that, well, upon information and belief, we think the confide app is going to be critical to the criminal proceeding. Well, maybe so. Maybe she knows something that we don't know. But the fact of the matter is that based on what has been filed in court today, there is no allegation in the indictment or otherwise
Right.
that the governor used the confide app.
Right.
So whether the circuit attorney and her counsel can develop an argument in front of Judge Burleson that can connect those dots and then connect the other dots, evidentiary and legal, sufficient to cause Messrs. Dowd and Bennett and their law firm to be disqualified, remains to be seen, McGraw.
Right. So here's the $64,000 question. Here's why we have you on the show. Because you're good on the legal side of this, but there's another side of this that I've come to learn just in watching the world go by over the last 20 years, is that there's a PR battle going on. And it seemed like Dowd Bennett was winning the PR battle. And this was this the circuit attorney's shot to sort of go on the offensive, whether or not this motion actually sticks? It sort of changes the subject. She's throwing mud at Dowd Bennett. Dowd Bennett's throwing mud at her. Is this her getting into that game?
No, I don't think so.
No.
It may have that effect, or a part of this motion may have that effect.
Right.
But I think in fairness and out of respect to the office, circuit attorney office and the governor's office, I think this is a legitimate motion that she and her counsel in good faith believe Judge Burleson needs to rule on, and she's going to pursue it.
Right.
As I say, to the extent that there's a public relations piece to it, or well, you moved Dowd Bennett to disqualify one of my people. I'm going to do the same.
Well, but Dowd Bennett went after one of her investigators,
Right.
and there was a story about him doing something wrong 20 years ago, and
right. And so as I say, whether there's a PR effect to all of that, so be it.
Right.
But just because in litigation, criminal or civil, McGraw, there is a PR effect, does not mean that one should not file the underlying subsidy motion. And that's my point, is that she presumably believes, and in good faith, that there is a good faith basis in law and fact to pursue this motion to disqualify Dowd Bennett. Okay, so be it.
Right.
But
she's got to show that confide is somehow involved with her case.
Well, she's got to show several things. First of all, she has to establish that that the representation in the civil matter was representation of the state in the same capacity and format as the state of Missouri versus Eric Greitens in the criminal matter.
Right.
And I think that's, shall we say, on a Monday morning, a pretty tall order.
We say that on a Tuesday morning, too, I guess.
Yeah. And the second is, and I think this will come out, is Jim Bennett and Ed Dowd are very careful lawyers. Josh Hawley is a very careful lawyer.
Right.
And clearly at the time of the civil litigation and then moving forward, they were very careful to make sure and dot their I's and cross their T's, not only for their client, the governor, but
right.
for the state of Missouri and in people of the state of Missouri in Hawley's case. So I think in the category of stay tuned, McGraw.
Right.
But in terms of back to your earlier observation, the mudslinging and the PR. Okay. Yeah, it has that effect, but that I don't think that was the motive.
Judge Rex Burleson says that Eric Greitens might not deserve or might not be available to have a bench trial. What did he mean by that?
In Missouri, the waiver of a right to a jury trial by a defendant, that waiver is not unilaterally. You don't have an autonomous right as a criminal defendant to flip a switch and say, jury trial, judge trial, bench trial. So what in Missouri, the waiver of the right to a jury trial and ordering the bench trial, that and requires the consent of the trial judge. And he may, and I think if you were to do a spreadsheet, McGraw, in the vast majority of cases, if a defendant agrees to waive his or her right to a jury trial,
the judge goes
along with it.
Gotcha.
But there is still that element of discretion. And if you think about it as a policy matter, probably makes a lot of sense because some people, if they're representing themselves, and for whatever reason, a criminal defendant proceeding pro se says, I want a bench trial.
Right. And
the judge said, I'm not going to allow that.
All right, here's a question we had from a listener a couple weeks ago, or a caller last week, and I said I would ask you the next time you were on the show, and that is this. Somebody said that somebody asked the question, if Eric Greitens takes the stand, does the prosecution get a chance to have a deposition with him before he goes on the stand?
No.
No.
No. They will, the parties will present their witness list and the case will proceed. And in many instances, the decision as to whether the defendant will testify or not testify is not made until after the prosecution rests its case in chief.
Right.
And so let's just hypothetically say on Wednesday morning, the prosecution rests, and Wednesday afternoon, the defense begins to put on its case, and they decide to put on the governor. While the defense may ask for a recess the prosecution may ask for a recess, I don't think there is any prospect that Judge Burleson is going to say, well, we're going to recess the jury for a week while you go.
Right. But the prosecution gets to depose the other witnesses, or no, or do they?
Well, you don't have to, unless you're subpoenaed by the grand jury, McGraw, you don't have to be interviewed by the prosecution. But depositions are taken under oath. But again, sitting here today, the governor's got a Fifth Amendment right against self-incrimination, and he doesn't have to testify. He doesn't have to answer questions.
Sure. Okay. That's
by the prosecution.
As my non-legal mind, that's how I explained it to the guy. But since I'm only halfway through
you got an extra credit hour that day.
I'm only 1/4 of my way through the first year of law school down at SLU. Thanks to you. All right. So he's got. Josh Hawley looking at him, investigating him for the Mission Continues email list with the campaign finance issues. He's got Jefferson City having hearings about hearings for his impeachment, and he has a criminal trial in the city of St. Louis. That's 3 fronts. He's got a dream team of lawyers. Greg Willard, what are you watching? What's your brilliant legal mind watching to see where all this goes?
I'm watching the impeachment, McGraw. I'm watching the impeachment for 2 reasons. Number one, I think the special committee is going to conclude its work pretty shortly, as in early April.
Okay.
And And if their report to the House suggests that there is a reasonable basis for the House to proceed with full consideration of impeachment, that will be an enormous step for a whole variety of reasons. Secondly, the reason I'm focused on the impeachment is we talked about it on the air before, and that is the standard to impeach a public official in Missouri is so low in comparison to a standard to convict in a criminal case.
Right.
That's enough for people to take up, to sit up and take notice in terms of, back to your question, what are we looking for?
Right.
In terms of, so that's number one is the impeachment. Secondarily is the criminal case. As you know, the governor has filed, I think, 2 motions to dismiss. Let's see how those play out. And then number 3 is this, the Attorney General's investigation as to the Mission Continues email list. That'll sort itself out.
The hearings to hear the impeachment, when that report's done, as you say, beginning of April, which is next week, there could be things in that report that are thoroughly embarrassing, thoroughly disgusting, thoroughly inappropriate, but not illegal, which I don't know if it's not going to help the criminal trial, but in terms of overall public perception, that report could be not beneficial to the PR angle of this trial down in the city.
Sure, it could be very harmful from the PR, and I think if we accept your hypothetical and as to what might be in that report, turn the clock back 20 years to a similar report by one Kenneth Starr in the Clinton matter, and we remember some of the tawdry footnotes in that.
Right.
So it didn't have an effect on the President Clinton's criminal culpability, but by golly, it sure had a public relations effect. But you make a very important point, McGraw, and that is this, that with this report from the House of Representatives Committee, it just highlights this axiom in Missouri. A public official need not have committed a criminal act to be impeached and thereafter convicted and removed from office. You can have engaged in other conduct which doesn't rise to the level of a crime, and that conduct may be found sufficient by the House, and then in the case of a governor, 7 judges, to be sufficient to convict and remove from office.
Keep your phone on and close, because we're going to be needing you over the next couple of weeks. That's Greg Willard. We'll let him get back to work. His day job is a SLU, St. Louis University law professor, and he's our legal analyst. Thank you.